more on individual claim arguments you can make to help lower your workers' compensation premium. Next up, we're going to talk about three-way contact, and perhaps there was a failure in the three-way contact. Three-way contact is good workers' compensation claims practices where the insurance company stays in touch with the claimant, the employer, and the treating physician. And by doing that, they can coordinate and make sure the claim is moving forward properly and that all parties are in the loop on what should happen next. Failure to properly administer three-way contact can result in a higher claim value. So an example might be that the workers' compensation company failed to contact the injured worker until 10 days after the claim was filed by the employer. And as a result, the injured worker got scared and went out and got an attorney and is now working against the employer with a claimant's attorney. That could be a reason that a claim value gets exaggerated, and that's a reason you could make an argument that the failure of the insurance company to exercise proper three-way contact procedure ended up in a higher claim value. Next could be an appeals board issue. The appeals board is where workers and employers go for disputed claims, and there are times when there are going to be hearings and the insurance company needs to send a representative. Some insurance companies use hearing representatives that are not attorneys. Some insurance companies use attorneys. But there are times when the insurance company fails completely to even show up at a hearing. Obviously, that results in an award to the claimant based on whatever the claimant is appealing or what the employer was appealing. The claimant wins the appeal if the employer doesn't show, or if the employer does a poor job in objecting to the issue at hand in front of the appeals board. So here's an area, again, where a good broker will have experts on hand that can help you with these issues, but we want to make sure everyone's aware that this is a possible issue and a possible argument you can make about why a particular claim inflated in value. Next up is apportionment of a prior injury. The law holds that a claim for permanent disability, which is obviously a very serious injury, the permanent disability portion of the claim can be apportioned back to another employer and another insurance company if, in fact, the injured worker had a similar injury in the past. So if you're well aware that you've hired an employee that has had a back injury in the past that was paid for by workers' compensation, and now that injured worker has another back injury while working for you, that claim can be split or apportioned between your insurance company and the insurance company for the prior employer. And often this is there's a failure to make proper apportionment. So if you're aware of an issue like this, it's a very good argument that the claim value has been inflated unnecessarily. Last issue we'll talk about in this segment is surveillance failure. We said before when we talked about fraud that this is a very frustrating issue for employers because there are many, many fraudulent claims, and because the system bends over backwards to help injured workers, there are times when fraudulent claims slip through, and it's very frustrating for most employers. Most employers have an experience with at least one fraudulent claim in their history. Often, employers will ask the insurance company to exercise surveillance, to go out and videotape the employee, and they'll be frustrated that the insurance company will resist doing that. And as we said before, there are legitimate reasons insurance companies resist because it's so hard to prove a claim of fraud. However, there are some areas where the fraud is so obvious and so easy to prove that a failure on the part of the insurance company to exercise surveillance could result in a claim being paid that shouldn't be paid. So an example would be if the employer is aware that that injured worker is actually working for another employer, and if that can be proven by surveillance, then that would be a very legitimate reason. If the insurance company failed to perform the surveillance, that would be a very legitimate reason to make the argument that that claim, the value of that claim should not count against the employer as the new underwriter considers future pricing.